Article is about contempt of court cases in India. Uh, the phrase contempt of court is used in the Article 19(2) as one of the grounds for imposing reasonable restrictions on fundamental rights, but Constitution has not given any guidelines how these proceedings will be initiated. Article 129 and Article 215 respectively make High Court, Supreme Court and High Court as the court of record, uh, which by virtue of which they also have inherent power to punish for its contempt. But the word contempt and the procedural complications have been discussed in the Contempt of Court Act 1971, which defines civil and criminal contempt. Civil contempt is defined as willful disobedience to any judgment, decree, direction, order, writ, or other process of court, or willful breach of an undertaking given to a court. On the other hand, criminal contempt is defined as the publication of any matter or doing of any act which scandalizes or lowers the authority of any court, or prejudices or tends to interfere with the due course of any judicial proceeding, interferes with the administration of justice in any other manner. So, uh, also the High Court and Supreme Court can initiate contempt proceedings on their suo motu. Also, such proceedings can be initiated by a third party, provided that the petition has consent from the Attorney General or Advocate General, respectively. Some cases where the contempt of court has been discussed is first Ashwini Kumar Ghosh versus Arabinda Bose 1952 case, which says that criticism that transgresses the limit of fair commentary can be held as contemptuous. Secondly, Anil Ratan Sarkar versus Hirak Ghosh, where it was held that power to punish for contempt should be exercised with caution and only be exercised where there is clear violation of an order. In the 2015 MV Jaya Rajan versus High Court of Kerala case, an individual court upheld a contempt finding against an individual for using abusive language in a public speech, criticizing High Court order, establishing that such actions could be considered criminal contempt for undermining the judiciary's authority and disrupting the administration and justice. In the recent 2025 Shanmugam at the rate Lakshmi Narayan versus High Court of Madras, the very purpose of the contempt for applying contempt of court case was to ensure administration of justice. Thus, it needs to be understood that any kind of misrepresentation and disregarding the authority of court is not only amounts to contempt, but it is also detrimental to democratic principles, affecting the delivery of substantive justice.